Welcome to the Meaningful Mediation Podcast, the place where leading lawyers and negotiators share their best tips and strategies for mediation and negotiation. I'm your host, Patrick Russell, a full-time Florida mediator and lawyer. My goal is to help you have an effective and meaningful mediation. Each episode will provide you with real-world strategies and tips to help you negotiate and mediate with confidence. Let's get to it. All right, welcome to the Meaningful Mediation Podcast, the show where we sit down with the sharpest legal minds, mediators, and master negotiators to pull back the curtain on how real disputes actually get resolved. I'm your host, Patrick Russell, and today I'm really excited about this conversation. My guest, Eric Rosen, is someone who has spent his entire career in rooms where the stakes are about as high as they get. Catastrophic injuries, wrongful death cases, families whose lives have been upended. He is board certified by the Florida Bar as a civil trial specialist and is also a graduate of the Trial Lawyers College. He's obtained more than $100 million in jury verdicts for his clients and is the founder of Rosen Injury Law. Eric, welcome to the show.
I appreciate you having me, Patrick. Thanks, man.
Awesome. Well, let's get to it. So let's start off with something that is unique to you. So you've indicated you graduated from Gerry Spence's Trial Lawyers College. And for listeners who haven't heard of it, Spence's program is famous for psychodrama and for teaching lawyers to tell stories the way jurors actually process them. How has that training changed the way you open a mediation?
That's a good question. So I went to the Spence Trial Lawyers College. Actually, he was alive at the time. It was back in 2012, and it was one of the most intense experiences of my life as far as kind of like their like method is learning more about yourself and like your flaws and things that you've experienced in your life and issues you've dealt with, so that you can kind of understand your clients' problems better, and put yourself in their shoes. A lot of psychodrama is actually like putting yourself in another person's shoes. And I guess when it comes to mediation, I haven't thought about it much, but I think having that training in those 3.5 weeks in the middle of nowhere in a ranch in Wyoming and doing all the psychodrama and the work that you do out there, you kind of naturally put yourself in other people's shoes and try to understand what they're going through. And I think for mediation, it's putting yourself in your client's shoes and trying to figure what is the best result going to be for them that they're going to be satisfied with. I mean, it's never going to be the perfect outcome because their life's been changed. But as far as getting some resolution, some closure, understanding that and then being able to execute on it.
And I guess what I indicated or got from your response, your initial hesitation, do you tell the story of the case differently at mediation than the way you would at a jury?
Yeah, I think so. A lot of the stuff with the Spence method is, when it comes to opening statements or closing arguments, and I think you could use some of it when you're doing an opening statement at a mediation, but a lot of it is putting on the witness and kind of getting them prepared for testifying. A lot of it is how are you going to effectively communicate in closing argument or opening statement and really bringing to life your case. So I think with respect to kind of coloring the case in a way to your opposing counsel and to the adjuster, you can use some of those methods when you're doing an opening statement.
Okay. And most of your cases with catastrophic injuries and wrongful death, the emotional stakes are enormous, and you're often sitting next to a family that's having basically the worst conversation of their lives. How do you prepare them for mediation?
It's not very deep. The preparation for mediation is not very deep. It's only because I go into mediation, unfortunately, skeptical that it's going to get resolved. And the idea is getting the client prepared for mediation is more of listen to what both sides have to say. You're not going to have to speak. You can just listen and kind of absorb everything and see what if the opposing counsel is coming at the case and liability is an issue, or maybe there's something with the treatment that came up during the course of the case where they may score some points, is to kind of listen so that they can evaluate what a little bit of the risks are going forward on both sides. And then that way they can be kind of make an informed decision on whether they want to get the case resolved. So, getting them prepared is, for me at least, is we're going to have mediation. Just listen carefully. Both sides are going to have a chance to present. You don't have to say anything. We'll be able to speak privately, and then we'll be able to communicate at that point.
And do you go over with them in advance some of the difficulties they may have in their case so they hear it from you first?
Yeah, of course they know what some of the difficulties are. Sure. I don't know if it's part of the preparation for mediation. I think it's just part of kind of going through the case and as it's progressing, what things look like with their case. And it's kind of staying in constant communication with them so that they understand and have expectations about what the result looks like. So that's one of the things I'm very, very an advocate of from the very, very beginning of every single case, is setting the client expectations so that they don't think that their case is a $20 million case when it's $1 million case, or they don't think it's and again, there's always the outliers that they hear about, and you just want to make sure that they stay grounded with what is a true value or a fair value to get the case resolved without the risk of trial.
Well, that's a perfect segue, because I was going to ask you about expectations. So What do you do, or how do you protect your client from a lowball opening offer where it doesn't blow up the mediation, where they get upset and want to storm out?
And that's a good point that you brought that up, because again, I can't, just sitting here thinking on the fly about what we talk about before mediation. That's always something I bring up before mediation starts. It's something it's always brought up. I say, listen, we're going to be at this number when we start, whether it's $1 million or $2 million. Don't be offended when they start at $15,000, because I've had cases settle for big numbers even when the defense is starting at $15,000 or $20,000 or $25,000. So it's more of a marathon than a sprint. So don't be offended by that number, because we just know they're going to do it, and that happens almost universally. So that's something we do get them prepared for, so they have that expectation and they don't freak out when they hear it.
Yeah. And I like that analogy about it's a marathon, not a sprint. That's so apt. I also like to say Rome wasn't built in a day, right? So
Rome was not.
Same concept. It takes a little while to build your settlement. Yeah. So let's actually talk about mediators. I'm interested in your opinion on this one. So you've worked with a lot of them, obviously.
Yep.
In your experience, what separates a mediator who actually moves a case from one who just carries numbers back and forth?
I think the mediator that has the experience of working on both sides, knowing plaintiff work, knowing defense work like yourself, understanding what value really looks like on cases, and someone that can effectively communicate to both sides, right? Like that plaintiff's lawyer can talk to the plaintiff client and explain to them, hey, I was a plaintiff lawyer for X amount of years. Like, this is what you're looking at. This is what I think. Kind of give a little bit of like an inside of what they believe. And then they can also speak to that plaintiff as I've also done defense. It doesn't always have to be that way. And then vice versa. That person who's done defense work can go back to the defense room and say, listen, guys, I've been doing this for a very long time. If I were the trial lawyer in the courtroom and I'm defending this particular case, I got this issue, this issue, this issue. And realistically, what's the value look like? And what's the report you're going to write back to the adjuster after this thing is over and we don't get it settled and da-da-da. Like, they have an understanding of that inner workings of the dynamic between defense attorney and adjuster, because I really think most of the time, if it's a personal injury case like mine, I don't think it's the client who caused the accident that has any role in making the decision to settle. I think it's the defense lawyer who's giving the evaluation of what I think this looks like, and then it's the adjuster who's also giving their own evaluation, but maybe they're going to weigh a little bit of what the defense attorney says, and then they got to go back and they got to talk to their supervisor who has a supervisor. So I think that mediator that understands that dynamic and can convey to both sides what's happening, not just going back and forth with numbers, but going back and forth with liability and damages.
Yeah. Now, sometimes a mediator may try to do exactly what you say,
Yeah.
But what if the other side only wants to talk about numbers?
What if the other side only wants to talk about numbers? And so mediator just has to go back and forth, and that's all
Yeah. What happens then?
that's all
Have
they're
you had
doing.
that happen at all?
Yeah, I'm sure that's happened. But a lot of times, and again, my experience is and sometimes it happens where we get a mediator that is not that experienced, maybe both sides, or my own opinion is that mediator is biased, right? They're walking into the mediation. My mediators are not supposed to be biased, but I've had seen it plenty of times where, and it's just like almost kind of a joke is we give them a number, they go back, and then they come back from with the other side's number, and they're like, here's their number, and your case is bad because of this, and this, and what are you going to do? What do you want to do? As opposed to, I appreciate a mediator, and I don't know what the full, like, what the rules are. You would know much better than I would about what, like, is there a universe how mediators are supposed to assist in getting the case resolved? I don't know. But I do know that some mediators, at least in my experience, will help with the negotiations. They get a feel. They're not able to say exactly what's happening in the other room. They're not able to give exact details unless the message is being allowed to be conveyed. But, sometimes I'll ask the mediator, what do you think? What do you think, like, a counteroffer would be, or a good counteroffer? Sometimes I take the advice. A lot of times I don't, like maybe because I'm just listening and kind of gathering information, but I don't see it often where the mediator is just the number going back and forth with numbers. It's usually a little bit more than that. They're able to kind of gauge on both sides what's happening. And again, I'm never in the room after I say something when they go back to the defense side, and what they're saying. So of course, I think both parties typically are a little more tight-lipped or careful about exactly what they're thinking or what authority they have.
Yeah, I agree. And it is a difficult and fine line. And yes, there are rules. There is a universe in which mediators are supposed to stay in. So it makes our job a little more challenging, but it's one that really works well when done the right way. So here's an interesting one for you. So without naming names, what's a move a great mediator has pulled on you that you admired? Something that you thought was unique and interesting that really moved the case?
I've had a few times where a mediator has said, we'll be working for a very long time and we're too far apart. It's not going to get settled. And they suggest doing something like a mediator's number or a silver bullet number to try to get the case done. Again, you know better than I do whether some of this stuff is right or wrong, but again, you never know what's going on in a jury room. You never know how the deliberations are, and those are one of these, like, it's a sacred thing that you don't get in. You don't learn exactly how the jury does their thing. Maybe it's similar with mediators, but when like a mediator's proposal or a mediator's number to get things done, meaning like, hey, listen, I've listened to both sides. I got experience in all this stuff. I'm gonna assist you guys in trying to get this resolved. I think this is the number. If both sides say yes, case is resolved. If one side says no, the other side doesn't know whether, you said yes, they said no, that kind of thing. I've seen that be effective a couple times. And I think that's good because it's kind of like, you always hear mediators say it. It's like the resolution is not everyone's going to be happy, but you're going to walk away. The defense is going to pay more than they want to pay, and the plaintiff is going to take a little bit less than they want to take, but it's a compromise. It's getting the case resolved. So I've seen that. I'm trying to think of some other moves. Yeah, I don't know. That's probably it.
Mm-hmm. Well, that's a good one.
Yeah.
A lot of your cases are against big insurance carriers, right?
Yeah, it's 99.9% of the time whenever I'm in a mediation, the other side has an adjuster from an insurance company, sure.
Okay.
Yeah.
And carrier adjusters are trained negotiators who basically evaluated thousands of files, and they do this day in and day out.
Yeah.
So when you open a mediation with a carrier, how do you actually make them move during mediation?
I think my, at the end of the day, when it comes to mediation, I think I know going into it that the other side has some authority, that they're showing up to this mediation. I don't know what that number is. I know the strengths and I know the weaknesses of our case. I know what the value is of the case, or at least a value that I think is a fair value to get the case resolved. The question is, how do you find out what their authority is? And then the next step is that it? Or is there a phone call that could be made? Is there, and again, this is just my experience over time. And I wish, part of me, wishes, but the nice thing is I have lawyers in my office that had done defense work. So they have an inside on what, the defense side looks like, and speaking to adjusters and writing reports, things like that. But really, I think the idea is, how do you get them to the authority, the actual authority? Will you ever know that that's really the highest number? And then are they able to make a phone call to get a higher number? And, I think there are times where we get the defense to the highest possible number that they're willing to pay without, we're just going to trial. I think sometimes it happens at mediation. I think truly there's probably, most of the time, you can get to whatever that highest number is and you can walk. And then there's another number that's going to be above that as things progress. But then the problem is you going forward with the case, incurring more costs, more time. Mm-hmm. At the end of the day, whatever number you get that's higher is going to be more detrimental maybe to your client, because now you've spent more money, you've spent more time. So you want to get the case done at a number that they're offering at mediation, or that they can make a phone call for. How do you get them there is being confident about your case, showing what the evidence is. Again, I don't like to always spill the beans about what my trial strategy is going to be, but I've had occasion where the defense, and again, sometimes these are judgment calls, but how do you get them up? I remember recently we had a case where they were nowhere near our number, and they kept saying to us, they kept arguing this liability issue. And I knew they missed something, and I knew I could hold it in my pocket and I can destroy them at trial with this one thing. But I also said to myself, does the client want to get this case resolved? Does the client want to eliminate risk of trial? Because there's still always the risk. And so I made a calculated decision. I'm going to let them know that. I'm going to let this one piece of info that they've missed, that they've overlooked, this answer to an interrogatory or whatever the discovery was, that they just they didn't capture it and then show it to them. And again, it's all a tactical decision and a strategic decision, but that increased the value like shockingly, by sharing a piece of information that I knew that they didn't have. That wasn't like we hid anything. It was that they missed it in the discovery that was already presented, the universe of information that was a great smoking gun. And so I said, you know what, I'm going to give them the smoking gun. And I'll give them, because there's no way that they're going to be able to fix it. They're going to look bad trying to fix it. Yes, I could surprise them at trial, but is that going to truly add value trying to get the case resolved, or is it going to add value even at trial? And so I made the decision, no, I'm going to let them know. And like I said, sometimes you got to do that. So sharing information sometimes is the right thing to do.
I think that sounds like a good call for you.
Yeah.
And I think sharing information probably makes my top 5 tips for how to actually get cases resolved. Because at the end of the day, even though you had this, let's call it the smoking gun, it still has to get disclosed, right? Before trial.
Yeah, they had it. That's the interesting thing is in this particular case, it was an answer to an interrogatory that was given by the defendant before the new defense attorneys got assigned to the case, and the prior defense attorneys for that client, that defendant, were removed from the case or withdrew from the case. And so it was in the existence of everything that we had. It was, I kind of just knew from the way they were speaking to me that they didn't look back at what was initially said from the earliest part of the case, before the defense lawyers really had a chance to kind of mold the case they wanted to mold. And so I knew they had this big contradiction, and this answered interrogatory was very, very powerful. So yeah, I mean, it does have to be disclosed. There's no doubt. I think sometimes it's strategically, did they miss this one thing? That's there in the records, that's there in the discovery, but they just didn't see it the way you saw it.
Yeah, for sure. I think that sometimes people have this misconception that we're in the era of Perry Mason, in the black and white drama, where all of a sudden at the last moment, kaboom, here is this wonderful evidence, and it changes the whole case and you lose, right? or you win, whichever side it is on. But that doesn't really exist in the real world, right? We've got to do disclosures.
There is, and this is when it comes down to strategy. And again, this has brought me a lot of success over the years, is that you need to gauge and really truly understand what are the cases that are more likely to go to trial, right? And if it's a case where you feel, hey, we can do whatever we can do, and we see where they're at, they're nowhere near our numbers, we have a very differing view, that is where, even when the information is all disclosed, because it has to be disclosed, that is where you take a strategic advantage and don't reveal what you're thinking, what your next move is going to be, and I'll give you a perfect example. There was a medical malpractice case that I tried in Miami, and I got involved in the case kind of later. Mediation fell apart. There was some negotiations that we tried to do just before trial, and around that time, the defense expert, I knew who the defense expert was. I was getting ready to cross-examine this guy, and I was putting it all together leading up to trial. And I found a book that this guy wrote, and there was a chapter in the book and on the exact issue that we were dealing with for this medical malpractice case. And he gave us the standard of care. He wrote in his own words, in his own book, that the defendant doctor fell below the standard of care in multiple ways, and all in his own book, in his own words. That's something like, part of you is like, if I let them know that, then maybe it's going to move the needle and they're going to get the case settled. But then you also say to yourself, there's no way like that. Why? I'm not going to give that to them. I'm not going to give them some really great cross-examination. I'm going to hold that in my pocket because I know it's not going to move the needle to an extent where it's going to get the case settled. And that was something that the defense expert had to have known about. It was his own book. The defense attorney probably didn't know about because he didn't read the guy's book. I did. And that unfolded in the courtroom in a Perry Mason moment. I fortunately have had a few Perry Mason moments, and that was one of them, where you're able to create this perfect moment in a courtroom. And those are the ones where you got to hang on to them. You got to keep them, The other case, the answer interrogatory, it wasn't going to be a Perry Mason moment. It was just something that was going to move the needle to get them to say, okay, there is a issue here. We have an issue.
The light bulb moment.
Yeah. What's up?
The light bulb moment.
Light bulb moment. Yeah, exactly. But the Perry Mason moments, you got to hang on to those.
Well, let's turn the camera a little bit. I ask every guest this next question, and most likely your answer is going to be different than from everybody else's. So every lawyer I know has a case, usually just one, that sits on the top of the pile in their head. It's the one they still think about when you drive home. It's the one that taught them something about themselves or about the system or what this job may actually cost. Tell me about yours. What's the defining moment of your career so far?
Oh, that's a good question. So we're talking about something that was like an amazing moment in a courtroom. Is that what you're trying to say? Like something that
something that changed, a defining moment for you. It doesn't have to be a victory. It could be a defeat. And then because of that, you overcame and adjusted and moved on and became somebody else.
I'll tell you the moment. I'll tell you there's something is one of those things that will stick with me forever. I'll tell you what it is. There was a case a number of years ago, and it was a tobacco case. I did a lot of tobacco litigation. A wrongful death tobacco case. It's a little complex, but I'll try to simplify it as possible. The defense and the tobacco companies spared no expense to find witnesses that were going to gut your case. They would go out and send out investigators. And so this particular case was like 2013 or 2014. Actually, it was closer to 15 or 16. They found this witness that had known my client back in the 1980s. She had worked with my client was a woman who smoked for many, many decades. She died from chronic obstructive pulmonary disease, very terrible death. But she had worked in a bar in the 1980s, and they went out and somehow found a coworker or someone who would go to this bar back in the 1980s. And so this woman had testimony that was going to destroy our case. And the idea was if our client had breathing problems or something before 1990, if there was a witness that said our client was having trouble breathing and they were coughing and they knew that it was related to smoking before 1990, we lose the case. We're going to lose at trial. And they found this woman, and that's exactly what this woman said, but it got worse. This woman talked about how our client was using inhalers in the 1980s, and she knew it was from smoking, and she couldn't breathe, and she was coughing, and it was like the worst witness ever imaginable. And they disclosed this witness, and I had to take her deposition. I had to locate her first, and somehow, by some miracle, I found her a Facebook post at a bar that she would attend, and I found a picture of a cozy of the bar that was on her Facebook page, and I called the bar, and she was sitting at the bar, and somehow I got her on the phone. But anyways, I knew she was going to ruin our case, and so we had to set the deposition of her, and I went to my a partner in my office, and I was like, she's going to kill our case. Like, we're done. And I said, what do you think I should do? And he goes, read this book. It's called Dynamic Cross-Examinations. Just read it. Get prepared and go up there and cross-examine her, but read the book first. So I picked up this book called Dynamic Cross-Examination, and I read through it, and I was like, this is a very different kind of method of setting the witness up in a way, and kind of not being scared to ask open-ended questions. And I really studied the book for like a week before flying up to, it was Inverness, Florida. It was the middle of nowhere. Met up there, and the defense did their direct examination by video. It was going to be a video preservation for trial. They did this video of this witness, and she destroyed our case. We were over. And I had my cross-examination prepared. I knew exactly what she was going to say, and I walked through this cross-examination of her, and she just looked so angry, and she looked so mean, and I got her talking about how she hates the idea of people suing tobacco companies. She thinks it's fraud. She thinks the smoker knows they did smoke knowingly and it was their choice, and end of story. They should never be able to collect money from a tobacco industry, and blah, 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 blah. And that ended up kind of being the main theme, really, of the cross-examination at trial. Even though she destroyed our case, and the defense wanted her to talk all about how tobacco lawsuits are fraud, and I highlighted it because it was my whole cross. It was a big part of my cross. And we played it. And a lot of people would have been scared to have the witness talk about how suing tobacco companies is a joke. You're just trying to get money. And instead, we turned it into, everyone has, listen, we have a right to a fair jury. We have a right to an unbiased jury. We have right to unbiased witnesses. And this witness is not unbiased. She's favoring one side. She's coming in here with this, all this testimony where she hates and this, she thinks that. And that was a big thing. And even though her testimony hurt us, we were able to minimize that damage. And I got a $13 million verdict, in that trial. And we got, punitive damages. And that was one of the first ones. It got affirmed on appeal. And that was a defining moment, was having to cross-examine this witness that was going to just destroy us. And I thought, and the best part of the story, I apologize, was after I first learned about this witness and what she was going to say, I talked to the client, and we decided we're going to get this case resolved. And I offered to settle for $50,000. And the defense said, our best and final is 35. We're never going to pay above 35,000. At that point, I went back to another one of my mentors in the firm, and I said, they're at 35 and we're at 50. And he goes, just try the case. What's the worst that happens? It's if you lose, everyone knows you're going to lose. And if you win, you're a hero. So I'm willing to back you. Just go try the case. It was one of those things where we tried a case over $15,000 and we won. So that was a big
one, big,
man. That was big. Yeah. That was a breakthrough breakthrough year for me, 2016.
Awesome. Well, that's really powerful. Let's get tactical now.
Yeah.
All right. This segment is what I call the Mediator's Toolbox. So it's the part of the show where I ask my guests to hand the audience a couple of specific tools, things they actually do in mediation or a negotiation that a lawyer listening could put into work, tomorrow. So let's keep it practical. Give me, 1 to 3 moves from your toolbox that you think are the best for mediation.
I think for mediation is never truly telegraphing where your actual drop dead number is. I never like to really let the other side know what I think that, again, these are like things that, you learn, and I think you got to go in and you're going to anchor high to some extent on things. That's just the universe of negotiating in personal injury cases, I think, is starting off high. Sometimes, and then there's no need to rush. Mm-hmm. Like, take your time. That's a big thing also. I've noticed, and I think its reality is that sometimes we'll make a move. We'll come off of whatever number, we'll make a counteroffer, and the mediator will go to the other room, and we don't hear from anybody for an hour. And I think it's almost like when you're leasing a car, or like you're buying a car, like you go to that dealership, you sit down on the table, and the salesman gives a number, and you give a counter, and they get up and they go somewhere, and they take however long. But I think there's a game that gets played. You have to understand the game and appreciate it. Is that everyone's just trying to tire you out. So for me, one is taking your time, really letting the client know that this is the marathon. Always bring food and snacks. It's something, just be hydrated, have something healthy, have a protein bar, or order in. Don't try to do this stuff on like an empty stomach and get cranky and tired, and then that's when you can kind of make these little mistakes. Anchor high. And you don't have to show your cards, until it's time, Mm-hmm. Then you can get to a point where you draw a line and you say, this is it. And they have to understand, if you have, the background, the experience, they understand where the line gets drawn, and there's no, they understand that. And if you have that reputation too, then they're going to appreciate it and they're going to respect it, and vice versa. Hope that helped.
Yeah, for sure. Now, let me ask you a follow-up question. I always find this one to be interesting. Do you ever share your bottom line with the mediator? And if you do, at what point?
In rare cases, and it's usually at the very, 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 very end of mediation, it's this is it or not, But it's not something that usually gets done early on, and sometimes it's not done at all. But and again, I don't know exactly what the mediator is going into the other room and saying. So if you want to get the case settled at, let's say, $250,000, and the other side's at 100, are you going to let the mediator know you can get it done at 250? Generally, the answer is, I'm not going to do that. They're going to be thinking, the mediator's not going to know that's the number. Because I don't know for certain whether the mediator is going to go into the other room and say, I'm feeling like it's 250, because as soon as the other side may hear something like a feeling, they may anchor to that feeling. They may, emotionally become attached to that feeling. And I've just noticed this. Sometimes I'm really, really good at negotiation. Sometimes I'm not as good. But I think, and it's just a matter of really, I think when it comes to mediations, most of the time I'm very, very good. Sometimes though, I want to be very, very straight and clear about something, and I will get to that number, and I'll say, this is it. There's nothing else we're doing, and I'll go right, and I'll say at that point. If I really want to get a case done. But otherwise, if it's not looking like they're going to get to the number with the moves that they're making, I'm not necessarily sure that I'm going to telegraph it to the mediator.
Yeah. And imagine if both sides do that to the mediator.
Yeah. Yeah. No, I know.
What you said previously is that you want to get their authority, right?
Yep.
And if they're also doing the same thing that you're doing, that they're not sharing their number until the very, very end.
Yeah.
You're automatically going to have a long session, aren't you?
There's going to be a long session, but I don't know that faster sessions have ever, listen, again, getting to that number too fast could emotionally affect the other side. And I know this, I know this to be true. Like I was recently, negotiating on something, and I gave an indication of where it needs to be done. but I made crystal clear to who I was talking to, that's where it needs to be done. There's no going below that. But when they're not near that number yet, right, where there's still a big gap, they still think no matter what, that's not the number. You know
There's
what I
a
mean?
chance, right?
Yeah, and so they keep inching up, and you got to keep saying, and then because then what ends up happening is that, again, it's a fine dance, but then what ends up happening is they emotionally get attached to where they don't truly believe you're at, where you truly believe you are at. They inch up, but then they get into a position where they have to start bidding against themselves. And no one ever wants to bid against themselves. So you get into this weird dynamic where, and again, that's something like I won't do. It's like if I come down and they say, no, you haven't come down enough, come down more. You automatically put me into a position where I'm saying, no, like you come up $1, come up $20, whatever, you got to come up, but I'm not going to make an offer and then come off that offer. How often, it's like one of those lessons you learn from as a baby lawyer is never bid against yourself, right? There's so many things that are unique about mediation when you're looking at midpoints and you're looking at brackets and then you're looking at midpoints of midpoints, then you're looking at the midpoint of the midpoint of the midpoint. It's like there's a lot of weird psychology that goes along with it. But how can you both try to quickly get to your number without affecting that psychology? And that's the reason, like you say, like, why don't people do it? Because I think it will affect the psychology. And I think that part of the psychology of all of this, and I've seen it, and I'll tell you another example that just from my experience, but the psychology of it taking a long time is necessary. I think it's necessary. And here's why I think it's necessary, is that I've seen in my experience that I think the adjusters on the other side will say, why did you move so fast? Why did you take this step and not take this intermediate step? Or why didn't you take this step? And I think that's what needs to be done for business purposes. I think they just need to know. Why did you pay them the full amount? Like, why did you pay them your full authority? Show me. And again, I don't know if this is true or not. I think just from my experience, it's true.
Show me the progress.
Show me the progress. You know it better than I do because you've worked on the defense side. You know what I mean? Like show me what the negotiation was. Because if the attorney or the adjuster goes to their supervisor and says, well, we came with authority at $100,000 and, our first move was 25 and then we went to 95, they're going to be in big trouble. Do you know what I mean?
Yep.
I think
there has to be, they're more of a linear process on that side.
Yeah.
Processes and procedures.
Yeah. But I also want to see it on my side. I think that that's important, like, especially even with with the attorneys in my office, I try to go to almost all mediations. And if I'm not at the mediation, the attorneys are reaching out to me during the mediation to get my thoughts on what the next move is. And when you have a really good mediator, you can kind of loop them in and kind of get their feeling on what a good next move would be. I think there's a process to it, and it can't be rushed. It's a dance. It's an art.
Yeah, I love that.
Yeah.
There are other folks that will disagree with you and think that mediation takes too long, and they find it frustrating. So as a mediator, often you're in between those two opposing sides.
Yeah.
And so it's interesting to hear from your perspective, and that's why I also interview people on the other side. And the whole idea is to try to learn together how we can kind of reconcile those positions, if at all.
Does the other side feel like it takes too long, or do they generally feel like that's just the process? They have to go through the process.
It depends. Everybody's different. So there are different lawyers that are a little more impatient, let's say, and some that are, more realists and follow your same line of logic. So, but it's interesting. Yeah. There's different buckets for different lawyers.
Yeah, and listen, you could get why get frustrated at that? Like if you set aside 3 hours, there are things I get frustrated about at mediation, like for sure. Like we recently had a mediation where, and again, it's like my side could be guilty of this also, but it's like the opening statement, each side takes an hour long. Then you have an hour left to try to mediate, you know what I mean, and try to get the case resolved. Like you just can't do that. Like everyone knows what the case is. Like if you put your few points out there, take 15 minutes to do your opening or 20 minutes. There's also the psychology for the client. They want to be able to see, hey, like I want to see my lawyer in action. Like I want to see, like you're ready to present. Let's see you present. and then they get to listen to the other side. But I've had cases where people have taken forever, and then you have a half hour to try to get the case resolved, and you're rushing, and the rush will never get it done. So there are things that are frustrating about the process, but I think, and maybe I'm contradicting myself from what I said earlier today. I don't think I am. I think for a long time, I did not like mediation. I thought it was the step to trial, and that's for a very, very long time. I never thought about mediation because I knew I was going to trial. It was like mediation is just one step, and it's
Was a check the box?
Check the box and go. As I've gotten older and more mature, and I think being a business owner, working on all types of cases, I've begun to appreciate mediation a lot more. And 99% of the time, I'm going to do everything I can to try to get the case resolved at mediation. I'm going to do it's not like me, like, I don't think cases don't settle at mediation for me lack of trying. Unless it's a case I just say, I don't care, like they're nowhere near our stratosphere, we're going to trial. I'm going to go in with an open mind that I want to try to get this done. I'll know quickly, or not quickly, I'll know in a couple hours whether or not we're anywhere near of getting it done at mediation. But I've learned to appreciate it more. I think it's a good space. I think it's a great tool. And again, listen, I think Gerry Spence said it. There's a great, great quote. You know, a lot of lawyers are, I'm going to trial and I'm going to try this case. I'm taking you to trial. Like, I don't take that view. Gerry Spence had a great view about it. And he's like, every trial he ever had, he did everything he possibly could to get the case resolved, except for selling his client's case short, except for settling it for under what it should be worth. But I've done everything I can. If I'm in trial, it's because you forced me to be there. And here we are. Things are going to, at least in my mind, things are going to get worse for the defense before it gets better if we're at trial.
Yep.
Because I've done everything. I've tried. You know what I mean? Like, I'm not like, I want to get cases done for just value, but I'm not going to settle it for less than what it should be settled for.
I love that.
Yeah.
So before I let you go,
Yeah.
Now we've spoken a lot about mediation, which is obvious, right? We're here on the Meaningful Mediation Podcast.
Yeah,
but I wanted to this is kind of my lightning round. All right. So 3 of your best tips for better negotiation outcomes. So it doesn't have to deal with mediation per se. And you don't have to, go on and elaborate about them, but it could be like listening, preparation, whatever it may be. But what are your 3 keys you think that a person out there needs to have a better negotiation outcome?
Okay, that's really good. So the first, just thinking off the top of my head, take your time. There's no rush to negotiating. This is one of the most important things, and it's funny, I make this mistake often, not as often as I like. Recently I made this mistake, but the mistake that I made, I said to myself, because it was funny, I got a call and I said, just take whatever their offer is, say to yourself, listen, take the offer, say, I appreciate the call, I'll get back to you, okay? There's no need to talk. There's no need to pound your chest and start arguing your point. If someone's conveying to you an offer, you can listen, you can absorb, and you can always hang up the phone. It's like, don't send the email so fast. Like if someone pisses you off, they send you an email, like, don't shoot that email off. Type it up maybe, but then put it in drafts and walk away. Best negotiating tool is listen carefully, take whatever their next move is, and then walk away for a minute. And then you have time to think about it. You have time to roundtable it. You have time to talk to people, talk to your client. That's huge because it gives you a chance to really strategize what your next move is going to be. So that's number 1. Number 2, I do love using brackets at some point. If you come to this number, we'll come to this number. I think it's a way to start speeding things up. Once you've inched up, they've inched up, you've inched down a little bit. Using brackets starts to speed up the process. And it tends to be your bracket is high, their bracket's low. Then you change the bracket a little bit, and they change it a little bit. And then you start to kind of see, I think, where the case is truly going to land. I think that's important, using those tools as far as negotiating. And I think you always have to start high. And I don't I don't mean that in a way like, you know, the other side has a $2.5 million policy. You think your case is worth 750 or 900 or whatever the number is. You got to start off at the policy limits. You got to start off high because I saw a video the other day. It was like from that show Yellowstone.
Mm-hmm.
And I didn't watch the show Yellowstone, but it was funny because the lady walked up to this guy who owns a ranch, and he says, you know, she wants to buy the ranch, and she says, how much? And he goes, I'm not interested in selling. I'm not interested in selling. And she says, I have a checkbook right here. I will write you a check for the number that you want. Tell me what you want. And he says $9 million. She writes the check for $9 million, hands it to him. Done. The thing is, she probably would have paid a lot more. You just don't know, right? Where that number is, where the truth is. And if you believe in your case and you really you value it where it should be, and let's say you think they have 750, but you've demanded 2 million, but you know, you think the value is 1.5, it doesn't hurt you to start off high, because you can come down slowly, you could take your time, and you can really figure out what is that actual value, what's their breaking point. You know, and if they're just not at your number and you're confident and you know you got a good case, your strongest negotiating strategy is being a great trial lawyer, having the experience and knowing that you can step into the courtroom against anybody and represent your client and win.
Awesome.
Yeah.
Well, those are golden.
Yeah.
Eric, this has been a fantastic conversation. So where can people find you if they want to follow your work, refer you a case, or just connect?
Yeah, no, it's Rosen Injury Law is our law firm. I've simplified things. It's getrosen.com. That's an easy way to find me, getrosen.com. And that's what we do. We have offices in Davie and Fort Lauderdale. We got a great team, a great crew of lawyers and paralegals and pre-suit paralegals, and we're in a phase of growing, and we love helping clients and working on cases.
And they can follow you on LinkedIn as well, right?
Oh yeah, I'm on LinkedIn, I'm on Instagram, I'm on TikTok. You can find me pretty much anywhere. It's Attorney Eric on TikTok. It's Rosen Injury Law on Instagram. And LinkedIn, it's yours truly, Eric Rosen. Look me up, send me a message, whatever you want.
Excellent. Well, thank you so much, Eric. It's great having you here. And to everybody listening, if this episode has helped you think differently about your next mediation or negotiation, do me a favor, share it with a lawyer or a mediator or someone who would benefit, and go ahead and subscribe to the show. You can find us on Apple, Spotify, or YouTube. Again, I'm Patrick Russell, your host, and this has been the Meaningful Mediation Podcast. We'll see you next time.
All right. Thanks, Patrick.
We hope you enjoyed this episode of the Meaningful Mediation Podcast. If you did, be sure to like, subscribe, and comment. Additional episodes can be found on YouTube and your favorite podcast channels. Until next time, less dispute, more resolution.